Woo! Good morning, people. They have gone underway at the SJC, the Appellate Court hearing. Let's get started.
And a multiple count indictment that she was tried on in Norfolk County. I want to first.
What is the factual basis for your assertion that the jurors who contacted the DA's office are different people from the ones who contacted yours?
I don't have a basis.
Okay, so when you say 7 or 8, that's speculative?
The numbers are that 4 of the jurors directly contacted the defense. A 5th, there was indirect proof.
Sure.
And a 5th juror contacted the defense. A juror who could have been one of the 5, could have been one of the 7.
Okay, so you're not representing that it's more than 5?
That's correct.
Okay.
What I am contesting is that there was no manifest necessity has met her burden of production and is therefore entitled to a post-trial jury voir dire by the trial court, at which we contend the probability, if not the certainty, that voir dire would result in proof that there was a final and binding.
Mr. Weinberg, you jump all the way to acquittal, correct?
Yes.
Under Rule 27, the verdict has to be unanimous.
Yes.
It has to be a general verdict returned by the jury to the judge in open court. And then the second element, the jury has to file a verdict slip with the clerk upon the return of the verdict, which is a written recital of that same verdict. Here, none of those elements were met.
Correct.
In the face of the juvenile case, in the face of Taylor, how is this an acquittal?
It's less a matter of labels. I could call it, Judge, a unanimous decision.
Well, you cite Taylor, which is the case in Quincy where the judge, basically there was a procedural defect in a complaint, and the judge, for lack of a better term, pulled the plug on the case, and we had to decide what was that. Was that procedural error, or was it a judgment on the merits? And we decided whatever the judge said, it was a procedural error.
Yes.
That case is an opposite to what this situation. So how do we say it was an acquittal without a verdict in open court and no verdict slip?
I think you say that there was a unanimous decision made by the jury that is subject to the proof that would come from a post-jury voir dire. I don't contest that this court should just impose an acquittal and substitute a verdict because of the declaration.
Well, that's a double jeopardy claim, right?
Yes, it's at the core of double jeopardy that if we can prove, and I suggest we've more than met the burden of production of proof, more than in many cases where this court is remanded for jury voir dires, that if that jury voir dire established, which is what we contend it would if ordered, that this was a final and unanimous decision made by the jurors, but they didn't announce it.
The post-verdict inquiry is usually or exclusively limited to extraneous information in front of the jury, charges of racism in the jury room, etc. Here, do you want us to carve out a new exception to that rule?
I think it's an extension of prior precedents. Fiddler talks about not establishing inflexible rules that would expense justice at the price of certitude. In Fiddler, there was evidence from the jurors that there was evidence received by a jury that didn't come from trial evidence. So that was.
Doesn't Fiddler caution to not inquire into the, to not to intrude into the sanctity of the deliberative process as well?
It does.
Absent this extraneous influence.
But
the
Chief Justice
Bud, not extraneous. It has to do with the very deliberations that occurred, correct?
I would argue that it has to do with the results of those deliberations, and that a carefully set of questions preceded by an instruction to a voir dire jury. We don't want you to disclose why you reached a result or the content of your processes, but we want to ask you about a result. Did you vote on count 1? How did you vote?
You seek to impeach the written communication by the foreperson, correct?
I'm sorry, Judge.
You seek to impeach the written communication of the foreperson, correct?
I wouldn't, I would say that the recent jury declarations demonstrated that there was facial ambiguity in those communications. Yes, they related to a lack of unanimity, to a deadlock about charges. The count 2 by itself, read vertically, had multiple charges. Horizontally, there were 3 separate counts. There was ambiguity. The trial court didn't realize it. The trial court erred in not allowing what Taylor and Stewart mandate as imperatives before there was a ruling of manifest necessity. No opportunity for a defense lawyer to make arguments about options to the declaration of mistrial, and I contest that there were at least 3 viable options that Stewart, Taylor, and all the cases of this court mandate be, quote, carefully considered.
You've got an exhausted jury writing this very eloquent message saying, we haven't been, we've done our best. We haven't been able to reach a verdict on any of the charges. There's no inkling in that they've reached verdicts on charges, or that this only.
They didn't specify any of the other charges.
Facially, there was the words charges and a word.
There you go.
In deadlock.
What's going to happen?
They didn't specify charges.
Right? Everyone thinks the jury's done its best. It's exhausted. It's tried every option, and everyone's resigned to trying the case again. I understand something happens later, but at least at that point, is it really a mistrial? I mean, is there an error to declare a mistrial?
I would respectfully disagree that everybody concurred that there was only one reading of this note when the defense had no opportunity, despite the clear jurisprudence mandating that they be given an opportunity to be heard.
Did the defense have an opportunity when there was a discussion about scheduling after the jury was sent into the room?
Once the judge discharged the jury, once the judge thanked them and said that the case is over, the failure to make an objection was futile. It was unnecessary.
What about the case of Como versus Enid Brown, where the jury was sent? The jury goofed, essentially. There was a miscommunication between the court and you know the case.
You have to understand these judges' job, they have to play devil's advocate. They have
And
to
then we said it
ask
wasn't
questions
error
to
bring
ensure
the
that
jury
they're making the
back
right
after
decisions
discharge to
in the end of the
clarify
day.
verdict.
Had the jurors that signed that or that made these representations starting the very day after the announcement of the mistrial, if they had told the judge.
But I guess the point I'm asking Mr. Weinberg is there was a time period, and I get your point that it was hasty to not have consulted with the attorneys before bringing the jury in. But be that as it may, after the discharge of the jury, I'll talk to you later, as most judges do. The lawyers then talk about a scheduling conference and timing of it. Wasn't there an opportunity at that point for the attorney to object and say, this is what should happen, these are my thoughts?
There was an opportunity, but not a responsibility. The law in this case, starting 39 years ago with Stewart, places the heavy burden on the Commonwealth, which wants to re-prosecute a citizen in the face of the decision of the first jury, to recommend alternatives to the judge. And the trial judge found consent, in part based on the failure to make an objection.
And I think we cut you off when you said there were 3 things that could have happened. Could you please tell us what those are?
Yeah, one is the trial judge receiving this note, and remember, didn't read the note to the defense, didn't give them an opportunity to be heard, said, bring the jury in. The jury comes in seconds later, 30 seconds, if the court were to look at the video, which has been relied on by my brother as well as the trial court. The judge could have said, I've received this note. Does it relate to all or just some of the charges? That's not a coercive question and has no capacity to coerce, the jury into redeliberating. It would illuminate the implied ambiguity, which is illuminated by the jury declarations, that there were 2 ways to interpret the note.
Don't you think we're supposed to assess the judge's decision-making or thinking in the context in which it occurred, which includes 2 previous notes reporting impasse? You argued very forcefully below that the jury had reached an impasse and for the Tui Rodriguez charge to be given. I'm assuming you made that argument in good faith.
The argument was made in good faith.
Yes, and there was no information intervening the second time you made that argument, no additional information about the jury's thought processes between that second note and the third note.
I would respectfully suggest that when a defense lawyer asks...
I'm not asking for an argument here. I was going to ask you for a reference to the record to indicate anything that happened in between the third note, the second note and the third note.
Yes.
That would indicate any less of an impasse between the first, second,
No.
and third notes.
Yes, what happened is that...
I'm just looking for a record site.
The record is the jury went out and deliberated for several hours, subject to a TUI instruction, which is designed to
There you go.
encourage a jury to reach a verdict when they've declared an impasse.
Right, so I understand your answer to be there's nothing in the record to indicate that they were at any less of an impasse than they were when they sent the second note.
No, and I would contend that all 3 notes are ambiguous. The defense...
That was not the argument you made below.
What?
The argument made by trial counsel was to argue not for a mistrial. They never asked for a mistrial.
I understand, but there
They
was
asked
no
for-
argument that these notes were ambiguous down below, correct?
Down below at the trial court, yes, the argument made on the motion to dismiss was
No,
that there
at the
was
time,
ambiguity.
not at the motion to dismiss, at the time.
They had no opportunity at the time to...
First note, was there an argument made concerning ambiguity in response to the first note reporting impasse?
No, there was a
Was
request
there
for
any
TUI.
ambiguity argument made in response to the second note?
There was a request for TUI. But the
Right.
only time that I suggest matters is the third note where they had no opportunity to make that argument.
Why would that be? Why would we just focus not on the totality of the 3 notes, but just the last note? Why is that, in your opinion, or actually citing any legal authority, why would that be the critical moment?
Because before that, there's at least an impasse on 1 count, and there is no obligation on a trial court in terms of timing when to seek a partial verdict. When Judge Discassiano asked me for what the 3 alternatives are, one of the alternatives was simply to ask the jury what it meant. The second was to apply Rule 27B, which says before a mistrial, a court may request of a jury whether or not they've reached any decision on any of the other counts. The reporter's notes...
At the moment of the declaration of the mistrial, what suggested in the notes, the 3 notes, that there was any agreement as to any of the 3 charges?
Facially, they
Nothing.
said they were at an impasse, and the court has an obligation to carefully consider all alternatives under Taylor and Stewart. There's no evidence on this record that the trial court made that consideration.
Well, after the first note, she asked counsel and the prosecutor, what do you think? And I thought defense counsel argued they've exhausted their review of the evidence, and so give the Tui Rodriguez, and the prosecutor said, not yet. And she said, yes, no, not yet. And then there was the second note where again, they report that they're in an impasse quite eloquently. And again, at that point, the prosecutor says, don't give the Tui Rodriguez, and the defense counsel says, yes, go ahead and give Tui Rodriguez. And she considers that alternative and gives the Tui Rodriguez instruction.
Yes.
Now we have the third note. We've really tried on all the charges. Some
They
of
never
us
said all
agree
the
that
charges,
beyond
though.
reasonable doubt, that the elements of each of the charges have been
That was never
established.
said.
Some of us do not.
And
And at that point,
All
she's
charges was
considered
never
the
specified.
alternatives. Let them continue to deliberate, give the Tui Rodriguez, and the third time, it sounds like that everybody's in an impasse. That's all the information she has.
and that's part of the perils of not providing counsel with an opportunity to be heard, which is what was required. because we
And
don't
not
know that the
specifying all
jury notes
charges.
1 and 2 didn't also relate to 1 rather than 3 counts. What the defense wanted was a verdict.
Weinberg's dropping the
If
ball
you
right
want a
now.
mistrial, you ask for
So
one.
your
They
rule
asked
would
for a
be
2 each.
that anytime there's more than one charge, the judge must ask, when the jury reports back that they're in an impasse, the judge must then ask, well, are you at an impasse as to count 1?
Right.
Are you at an impasse
Exactly.
as to count 3? That's the rule.
When there's a multiple count indictment, that's
Of
the rule
course.
as described by the reporter to 27B, which is a trial court must make that inquiry before ordering a
Exactly.
mistrial.
I thought it was a May, Mr. Weinberg.
The may was in the rule. The reporter's note says must. I would argue the may relates to timing. In other words, there's no obligation of a judge at any particular time to ask the jury whether there's a partial verdict. But if you're going to issue a mistrial order, that's where the must comes in. And
In the ordinary case, the foreperson will say, we've got a verdict on counts 1 and 7, and we seal them, and then we continue on, and we can mistry the remaining counts, correct? When you say it wouldn't be coercive to ask, am I right to assume that you're relying on Rule 27B?
27B and the distinction in the Roth case, which is there is a risk of coercion if you're dealing with a single count with multiples. But 27B preempts that in terms of the importance of a mistrial order.
In your argument to Justice Wendlandt, and I guess to me as well in the court, is that that is not discretionary.
My argument is that given the core values of double jeopardy, that unless the defense consents to the mistrial order, the court has to comply with the guidance, the principles, the mandates of Stewart and Taylor. And here they complied with neither one of them.
And that's absent any other evidence as far as the deliberations go and the notes that there's an agreement, or at least partial agreement on a particular verdict, correct?
Yes, those notes were subject to one of 2 interpretations, and given the obligation of a trial court to consider all alternatives, including the alternative post-TUI of seeing whether the jury wanted to deliberate on any one of the 3 counts, which is part of the statute. I think it's 268-34C. That's a third alternative. Here, the problem is the record doesn't reflect the trial judge's consideration.
As a matter
of
of
these
fact, were there
alternatives.
3 separate verdict forms?
There was actually more than 3 verdict forms because the verdicts on count 2 had multiple, they had 3
So
different options.
count 1 and 3, were there separate verdict forms for those?
I believe there was separate forms, but there was, guilty, not guilty, count 1, count 3, and count 2. There was supplemental instructions and an amended verdict form to make sure the jury had options that were consistent with the law of the SJC as to how you deal with lesser includeds.
Can I ask, sorry, so I'd like to ask, the judge says she can't ask the questions that you're saying she could without interjecting herself in deliberation. So let me read what she says. While the defendant contends that the conflict is reflective of the fact that the instruction given to the jury by the court were confusing, determining whether this is true would necessarily require inquiring into the back and forth among the jurors.
No, it would not. Yes or no questions.
Yes.
One yes or no
How
question.
would she do this? She doesn't.
Guilty or not
envision a
guilty
way
on
that she
these
could
counts.
Ask the
Easy.
questions you're talking about without requiring them to explain whether they took votes, how they took votes, what the votes were. Just tell me what your thought process is on
My
that.
thought process, one is that this court has the option of essentially informing the court what questions could be asked. And 2, if we're going to delegate.
Require follow-up questions. And unlike extraneous
No, it wouldn't.
influences,
Oh my God.
where you can say, okay, we only want.
Weinberg, just tell them yes.
inquire about whether
I'm just
there was
asking for yes or no
mistake
questions.
or something to that effect. This is different. We're going to have to require
Guilty or not guilty questions.
what their
That's it.
votes were and how solid
On
they
3
were.
charges.
Isn't that going to get into deliberations inevitably?
I think you could ask about the results of deliberations. I would design it by saying an instruction to the jury to not disclose the content or your processes of deliberation.
Right.
But I want to ask you the following questions. 1, did you take a vote on count one. What was your vote? Was the vote unanimous amongst other jurors? Was the vote final? Was it ever reconsidered or rediscussed?
That's it.
Final. Isn't that gonna, the jury can change its mind, right?
Could, but there's no.
But isn't that gonna result in asking that type of question? When you say final, if you don't get your way on two, is it final?
Was it ever reconsidered? You know, my contention, based on these jury declarations, based on the voicemail, based on the fact that in this highly publicized case, no other juror, they served for months, says to anybody, to the court, to the clerk, to the court officers, to the prosecutor, wait, I didn't agree.
They also don't write in saying we agree with the other five or anything to that effect. They're silent.
Is that Sarah Boone back there?
Their deliberations are supposed to be silent, right?
But it's an almost unprecedented meeting of the burden of production. If this was a Sixth Amendment issue, the jurisprudence of the court would compel a post-jury inquiry. The Fifth Amendment values are just as important. Questions can be designed, whether it's final or was it ever reconsidered, that would demonstrate what we contend. These were final votes. This was the end of counts 1 and 3. It's exactly what Juror D says. We went to the bus and says, no one's ever going to know that we voted to acquit.
Isn't that part of the problem? And isn't that what Bloford counsels against? Because you keep saying that whatever was done on counts 1 and 3 were fixed. And despite the fact that there was potentially still some uncertainty about where the folks were on count 2, that could never change in the continuing deliberation about count 2. And isn't that what Justice Roberts was talking about? The deliberations weren't finished. They weren't finalized. And you keep using that term. But there's still opportunity for folks to change their positions in the context of the continuing deliberations on count 2 and its lesser included. So what's your best authority to say that it was fixed for all time and for all deliberations, and there was no opportunity, particularly when we don't know that no one, to Justice Cathcar's point, has called and said, hey, me too, we believe the same thing, for the court to say that this is what it meant for all time?
So, and the answer to the question, and I understand the question, in the Bloford case, you know, we had the return under Arkansas law, which prohibited partial verdicts. The jury said that they'd reached a decision, they were sent out again, and then they said they had changed that decision and were at an impasse. In this case, a post-jury voir dire can ask about whether or not you took a vote. Was it unanimous? That doesn't intrude on the values of 606B. Was the vote ever reconsidered? Was it final?
But that's my point. If you stop right there and say that's the end of the inquiry, that's really not true, because there's still deliberations that are left on count 2 that might inform a juror's change of position on count 1 and 3.
And that could be the subject of a jury inquiry as to whether or not the unanimous vote that acquitted Miss Reed of murder and leaving the scene was ever reconsidered. You can ask for a result without probing into a mental process.
There you
into
go.
the content of
Exactly.
deliberation. The values at stake here are too important. Yes, in the McCallop case, you know, we allow a court to ask about mental processes. Was there communications of bias?
What about
Fiddler, they
my
talked
client's
about
rights?
Communication of evidence that wasn't received through the gatekeeper function of the trial court. This is important. Miss Reed was acquitted by those jurors, and we should have the opportunity.
There you go.
Not acquitted. We contend a unanimous vote. We should have the opportunity to have Judge Cannoni conduct a voir dire. It's done when one juror says there was a statement of bias, when one juror says there was contact with an external source.
Right, but when it's an extraneous source, then you need not get into deliberations. But as I listen to you suggest questions that the trial judge could have asked, it seems to me those questions go directly to the jury deliberation.
They don't. Oh my God.
Pretend they go to the results of the deliberation.
The results of the
Not
deliberations.
require a judge to ask Why did you vote not guilty? What led you to vote not
So
guilty?
the question
Did you
asked
vote
to
not
juror F would be, was that vote final?
Yes.
Juror
That's
F's
it.
answer would be, well, no, it kind of
Yes or no,
depended on
please.
how
Cut 'em off.
I
Yes or
would've
no,
voted
please.
On count two, we were not yet done.
And that would reflect two
It's a
things.
jury deliberations, right?
That would reflect that the voir dire by the judge did not lead to a result of a final unanimous verdict of not guilty. But to foreclose those inquiries when there's a real possibility 12 jurors are going to say to Judge Cannoni, if conducted, that was my vote, it was not guilty. We never reconsidered it. We considered her innocent. We didn't think she intentionally killed anyone. We should not be foreclosed from having that option.
It seems to me that what you are in effect asking via a post-trial inquiry is to discover whether the jury disregarded the jury instructions. And the reason why I say that is that the jury were instructed to return a verdict after the final vote, and I'm using that as a direct quote of the jury. So when they had a final vote, they were then to check the appropriate boxes as to each charge, then sign and date the verdict slip.
How can they check
It
a not
seems to
guilty
me,
box
or
when there
please
was no
correct
not
me,
guilty box?
Why isn't this post-verdict inquiry that you're suggesting actually an attempt to try to establish that the jury didn't follow the instructions? We have a long line of jurisprudence that says we presume that the jury follows the instructions.
And there is cases where, when mistakes are made by jurors, where they don't fill out the verdict slip accurately. The
That's
Capen
not
case.
this case, though.
No, this case, I think, is a stronger case for a voir dire because we're not impeaching a verdict. We're explaining a note. We're asking the jury to resolve an ambiguity within the note that the trial court didn't realize, in part because they didn't provide an opportunity for argument, in part because they used a procedure that's totally at odds with this court's jurisprudence in Stewart and Taylor. And before we get to the voir dire issue, we contest there was no manifest necessity. And
Before you shift back to that, what's the best case? That's federal, because we're interpreting federal law here. What's the best, closest case, and not an extraneous influence case, allowing this type of probing after? What if we want to go back and read one case that's going to do what you want us to do? What's the closest case?
It's actually a Mississippi case. I think it's named Martin versus State,
That's a-
that the amici
That's a
brief
state court
brought us
case, right?
to, where they read
It's
the
a state
newspaper.
court case,
Yes,
right?
it is.
Any federal cases? Because again, this is a federal constitutional issue.
You know, there are cases where jurors correct verdicts.
No federal case
This is,
that has the, you're asking us to direct Judge Cannoni to do this. I just would be helpful if you have a federal example that we can turn to, because we're interpreting federal law, not our own law here.
But that's because
court
this has
has a
never
long
fucking
history
happened.
of applying
We don't
Because
have any
every other judge knows
except
how to do their
extraneous
job except
influence.
Judge
Just look-
Cannoni.
Again, your chance.
You do
Best
have-
case that we should look at for you.
You do have one example, which is the McCallum case, which follows a Supreme Court case and allows the jurors to disclose their deliberations regarding ethnicity and racial
Again,
bias.
that's extraneous influence. That's different.
It's internal to, I think it's closer to the core of 606B.
No federal case we can turn
There's-
to, for example.
Nor has the prosecutor come up with any case to the contrary. This showing by this jury, it's not going to open the floodgates for post voir dire.
Well,
This is-
actually, that was my question. What's the limiting principle here? It sounds like if ever a juror comes back to the defendant and says, hey, that's not really what happened, then we open it up.
This would not be a case where a juror has second thoughts, is reconsidering, didn't think to.
You can't really say that.
In the jury room. These are representations by 4 jurors that were unequivocal, unconditional. They said we reached a final verdict of not guilty, and I
So the
urged
jurors submitted affidavits?
the jurors would submit affidavits. If we asked the judge, if you're not going to accept the lawyers' affidavits, please authorize the lawyers to go back to the jurors. But we didn't want to walk near the boundaries of 606B. The judge accepted the truth of the lawyers' affidavits as a substitute for the jurors' affidavits. But again, let us voir dire the jurors. The judge has the power to make a decision. Was there a unanimous verdict of not guilty?
But our review is an abuse of discretion. Why was it an abuse of discretion for her to deny you that ability?
Because the Stewart case says the deferential, appellate review
Oh my God.
depends on whether or not there's proof of compliance with the principles set forth in Stewart, meaning did the judge carefully consider all the options? Did the judge give the defense a full opportunity? These were mandates, not discretions. They're conditioned precedent to the declaration of manifest necessity. It simply wasn't followed in this case. It wasn't followed the basic rules. It's Floyd P., which is when a jury gives a note, you share it with counsel, you listen to counsel, you get their views. We don't know whether counsel would have advised the judge about 27B, or would have asked the judge to ask the jury whether to.
Counsel, can I go backwards on that?
Sure.
Because part of I don't know what part of this goes into the calculus, but you have two extremely experienced trial lawyers. No one in that room would ever think potentially a mistrial may be declared after Tui Rodriguez is given. There isn't any lawyer that's worth their salt that wouldn't think they might get a mistrial on this. So you know where the puck may be going when it comes to giving the Tui Rodriguez. And you say that there was no manifest necessity for this and no opportunity to be heard. How do we factor in that you've got to know that that's going to be on the table? Is that a mistrial? And what obligation is there on counsel to say, hey, before you declare a mistrial, let's talk about alternatives to that?
So let me address that. Judge comes in, deviates from her prior practice where she gave counsel a full opportunity, announces to the defense lawyer there's an impasse, bring the jury in. If your honors would accept the audio video that again the district attorney has relied on, it's about 30 seconds till the jury comes in, but you hear a door open. Defense counsel don't know what's in the note. It hasn't been read to them. They don't know what the judge's intentions are. They don't know whether they'll be invited to come to the bench to discuss it. They have to be surprised they weren't given an opportunity. They hear a door open. The jury could come in 5 seconds, much less 30, and I stand before you with 52 years of trial experience to say no competent defense lawyer would risk the wrath of a judge or jury by interrupting that process, by making objections. So
The judge said they're at an impasse, bring in the jury.
bring in the jury and you can actually hear a door open.
Okay,
So
and you have 30 seconds to object.
but you don't know that it's not 5 seconds. You don't know the door's not open. You don't know the
You
jury.
can say,
can't
Your
hear.
Honor, may I see you at sidebar?
In this case, that's happened repeatedly? No?
Oh,
Here,
fuck.
the defense lawyers did not know what the judge's intentions were. They didn't know what was in
But
the
they
note.
did know that the jury had reported to her that they were at an impasse.
They were at an impasse, bring the jury in.
You're putting
Yes,
this on the
that was
defense when
possible.
it's the judge's
But to
responsibility
ask
to give these
to ask to go
instructions?
to the bench, but
Yes.
this court.
And did that happen?
No, but neither did it happen that the prosecutor, who this court says has a heavy burden because they're the sovereign. They want to
Exactly.
prosecute somebody after a mistrial to subject them to the perils of a second prosecution. The trial court did not impose a burden on the prosecutor. They have more of an obligation in double jeopardy law to raise options to a mistrial. And I don't think it's fair to conjecture consent or to penalize a defense lawyer when they have been relying on a procedure that's lawful, where defense lawyers have a full opportunity. to be
Exactly.
heard. They don't know what's in the note.
She doesn't need the consent of the defense to declare a mistrial. She needs to determine that there was manifest necessity for a mistrial,
After a
correct?
careful consideration of all alternatives and after giving the
That may
defense an
explain why
opportunity.
perhaps she didn't, the judge did not inquire, was because given, I don't mean to replow the same territory, but this was the third note.
It was the third note, but it was a note that demonstrated, because of the deliberations between the second and third, that the defense didn't want a mistrial. They wanted a verdict.
Mr. Weinberg, are you aware of any cases, or can you let me know if there are any cases where the judge gives TUI,
Yep.
and then the jury comes back and says, we're deadlocked, as articulate as this jury was or not, and then the judge does something different other than just declare mistrial?
Well, the statute itself says the judge has no right to obligate the jury to redeliberate, but every right to ask the jury whether they would consent to continue deliberations. And here I
But
contest.
here, the jury said to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs.
Right, and in the face of that, do you think give it the old college try is okay?
I think that the judge had alternatives that the record does not reflect were carefully considered, including, is your deadlock on all three counts? Is there any-
Exactly.
Would you consent to
It's that
deliberate
simple.
on any count that you've not reached an irrevocable deadlock? Questions like that are not coercive. Questions like that would have
Right.
actually given the illumination post July 1, and I'm not arguing that that provides proof as to what the process was on July 1.
In the statutes.
This is
again,
infuriating.
Is it may, correct?
The statute says 27B says a court may make that request, but the Stewart and Taylor rule require careful consideration. That at minimum was an option not considered.
The careful consideration is basically all that has gone on as far as the length of deliberations, a number of notes, et cetera, and what the notes say. That's part of the calculus, correct?
Yes, the judge made her own judgment, and I'm not saying the judgment was irrational. I'm saying that she would have been aided by counsel. The law required she give counsel an opportunity to be heard. There's no evidence in the record she considered any option except to declare a mistrial. That contradicts the clear jurisprudence of this court, and I contend it contradicts the core protections that double jeopardy give to a defendant against being re-prosecuted, which the Supreme Court has said carries with it the risk that an innocent person can be convicted, the ordeal of a second prosecution. This court has given procedural guidance, conditions precedent. This is what the words are must. 27B may be discretionary, although we argue the reporter's note in combination with Taylor required that inquiry about partial verdicts. This court has told the judges ordering a mistrial is irrevocable. And you need to go through certain procedural conditions precedent, and the judge did not. And I respectfully submit that extinguishes the principal basis to say there was manifest necessity in this case. There was never a knowing and intelligent consent. The defendant never asked for a mistrial. And at minimum, secondly, we strongly ask this court to extend the Sixth Amendment jurisprudence, where you allow jury voir dires into the Fifth Amendment. The Fifth Amendment is as important as the Sixth Amendment, and a jury voir dire conducted by an experienced judge can determine whether or not there was a unanimous and final verdict of not guilty on 2 counts, one of which carries with it life imprisonment. I thank you very much for the privilege of appearing before you today.
There you go. I love it.
Okay, Attorney Schellinger.
Good for you, Marty Weinberg. Good for you, buddy.
At council table is my colleague, ADA Laura McLaughlin. I'd like to start with the mistrial issue and emphasize a point that has been touched on through the questions to my brother, but that I think is important for the court to consider, and that is the trial strategy here. As a general matter,
Here come the smoke and mirrors.
absent some sort of definite indication from the jury that they're prepared to find a defendant not guilty on a charge, effective defense counsel is not going to ask the judge to start probing, or not going to want the judge sua sponte to do that, because doing so runs the risk of extracting a guilty verdict and convicting your client instead of obtaining a mistrial across the board.
But what do we do with the fact that after the third note, the jury is called in? There's not, unlike the first and second note where she says, okay, counsel, let me know what you think.
No, this
Here,
isn't
we
Brennan.
don't have that opportunity.
This isn't Hank
The
Brennan.
judge did inform counsel that the jury.
I don't know
was
who
at
this
an
guy is.
impasse, and I would argue at this point, it is clear that a mistrial is inevitable or unavoidable. The jury has twice already returned deadlocked. The defendant has argued strenuously that they are deadlocked. They've been given Tui Rodriguez, and now the judge informs counsel they're at an impasse. At that point, counsel couldn't credibly believe that the result here was going to be anything other than a mistrial. And again, in addition, just to circle back, all the more so, Your Honor, because of what was their defense in this case. The defendant's defense was that she didn't cause the victim's death, but allegedly had been framed. If the jury were to come back with a guilty verdict on any of the charges, or either of the lesser included offenses, they would have necessarily had to find that the victim did cause, or excuse me, the defendant did cause the victim's death. And it would have been a rejection of that defense and the defendant's public narrative. The defendant here did not want the judge to do more into
Rather
the
than
part.
speculate what the defense wanted.
What?
Let me ask you about what happened. Did the judge have either the discretion or the obligation to ask the jury after the last note about continued deliberations or a verdict on any lesser included offense?
No obligation, Your Honor. It perhaps is a matter of
Did the judge have the discretion to do so?
Rule 27B is discretionary. The language of the rule itself consistently refers to what a judge or a jury may do. I know the defendant argues.
So it's not inherently coercive.
So
If the judge has a
Cherry, the
discretion,
Bukkake Queen, member for 8 months.
Well,
Thank
no,
you
it's
so
a matter
much.
of
Check
discretion
DMs.
and then consider
Check
the factors
DMs
for
asshole.
the exercise of that discretion.
I don't know
That's
who
what
you're
the judge
talking
did
to, but
consider.
okay.
On the one hand, the judge
Thank
had
you
no doubt based on the jury's
for being a
notes that
member
they
for
had
8
not
months.
reached agreement on any of the charges. Further, the jury's third note had triggered 234A 68C, so they couldn't be compelled to continue deliberating. They made it abundantly clear they did not consent.
Unless they want to.
Unless they wanted to, exactly. But indicated that if they were forced to continue deliberating, any verdict they returned wouldn't be a just verdict. It'd be the product of compromising their deeply held beliefs and moral convictions. You have that on the one hand informing the exercise of discretion. On the other hand, you have strong countervailing reasons that argued against making further inquiry here, which is the potential for coercion. You have a jury that has sat through a grueling 10-week trial, nearly 100 witnesses, hundreds of exhibits. Now 4 or 5 days of deliberations, they've returned 3 times indicating that they are deadlocked, they are at an impasse, and they do not want to continue to deliberate.
But counsel, I'm sorry to interrupt you on that because I don't want to miss this point. But wouldn't that go to the calculus of manifest necessity? Because all of those things seem to be the reasons why you would tell counsel about the last note and say, what do you think? Because you have gone through this 10-week trial. You have gone through the impanelment process. You've spent a lot of time, energy, and money, anxiety, and angst in this trial. Why, when we talk about what potentially we could do short of saying, mistrial, let's start again?
Certainly, Your Honor, and I think, in hindsight, seeing, the quote unquote remarkable turnaround of the defendant's position, would it have been better, would it have been preferable for the judge to take that extra step? Perhaps, and another judge might have done that. But here, given the progression up to the third note, and in particular, given the defendant's response to each of those 2 prior notes, I think the judge could reasonably conclude the jury is at an impasse. There is a manifest necessity for a mistrial. There is nothing more to be done here. And in fact, in her order denying the defendant's motion to dismiss, the judge did say a mistrial was inevitable.
You can't find consent, right? If you don't ask, the consent is out the window, isn't it?
Right.
I agree, Your Honor.
Really?
Fine.
Really?
Even the burden of proof is on the Commonwealth.
There you go.
There's no opportunity whatsoever for the defense counsel to raise anything.
Right.
I get manifest, you may have manifest.
Yeah, so these
necessity,
judges
but I don't
just
see how
have
you
to
can get
ask
consent
hard
from
questions
anything
to come
in
to
any way.
the
They
best
were
answers.
consulted in response to the first two notes. And what was the defendant's response to those notes? It was to argue in favor of doing thorough deliberation and accelerate the process at every step toward a mistrial.
But pushing towards a verdict is different from, that's different. I mean, they want a verdict. Because they want Tui Rodriguez doesn't mean they've consented to a mistrial.
Even so, Your Honor, they had opportunities to object. They could have objected while waiting for the jury to enter the room. 30 seconds is ample time to at least ask, may we be heard at sidebar, Your Honor, after being informed that the jury's at an impasse. They could have brought the issue up again during the scheduling conference after the jury was excused to the jury room. And even after that, they still could have brought it up. And we cited in our brief Fuentes as an example of where a defendant lodged an objection after the fact, after the jury had been excused to the jury room. And at that point, the judge did still consider counsel's arguments. And I think given the defendant's response to the prior notes, it being clear what the defendant was advocating for here, and at the point of the third note, it being unavoidable based on manifest necessity to declare a mistrial, the absence of an objection here, or even asking to be heard, Your Honor, indicates consent.
You might have, I know it probably is in your brief, but what's your best case for that?
This case is closer to Pellegrin, Your Honor, and very different than Horrigan. So as between the two, certainly where there is something abrupt that happens that is inconsistent with the way defendant has conducted him or herself, the approach that they have taken during the trial, it would be difficult to find consent. Horrigan is an example of that. Judge comes in, abruptly announces, trial judge is unable to preside, I'm declaring a mistrial. There was no indication there that, the defendant was in agreement with that. But here, again, where you have the defendant advocating for the result of a mistrial, the ultimate conclusion of it, when it is then ultimately declared to not...
How do you know the defendant is advocating for a mistrial?
There you
as
go.
opposed to
I was just about to ask the same question.
Because, Your Honor,
How do you know they were advocating
what
for
they
it?
are
Because Tui, there's two results of Tui. It's either a verdict or it's a mistrial, and it pushes the jury to its extreme. So when you say that they're advocating for a mistrial, they could have been just as well advocating the jury for that final push.
There you go.
Rodriguez instruction says
Exactly.
you need to check yourself. One side has the
Before
burden.
you wreck yourself.
It's very favorable in some instances to a defendant. So how can you stand up here and say that they were pushing for a mistrial?
Perhaps as to just Tui Rodriguez, although as a practical matter, as Justice George has pointed out, experienced defense counsel understand that there's not going to be a mistrial before that instruction has been given, or very likely. But set that aside, Your Honor.
Well, I think experienced counsel know that you're most likely not going to get further deliberations, but counsel also know that it could very well, it's a flip of a coin. It could be
Big dicks in your mouth is bad for your health.
Right. On top of that, Your Honor, I would point to, in response to the first note, the Commonwealth argued against a finding of due and thorough deliberation. Hasn't been enough time, let the jury continue to deliberate. Already at that point, the defendant was prepared to argue there's been due and thorough deliberation. I think the exact quote is, we believe there's been sufficient time. Disagreed with the Commonwealth's reading of the note from the juror that there might still be the possibility of reaching a unanimous verdict, arguing they'd already exhausted all manner of compromise, all manner of persuasion. So, and then again, in response to the second note, again argued there's been due and thorough deliberation. Those arguments are pushing to the point where 234A 68C is triggered, and the jury cannot continue to deliberate, and a mistrial will have to be declared unless they consent to further deliberation.
I think it's safe to say that they were pushing for a TUI instruction, correct?
Yes, they asked for that as well in response to both notes, Your Honor.
Ask for it as well as what? That's what they asked for. What are you talking about, guy? See this
No,
shit they
Your
try to
Honor, there was
pull?
manifest necessity for the declaration of the mistrial here.
And so absent the consent, you can just, you think the manifest necessity existed?
Yes, I don't think that the judge abused her discretion in declaring a mistrial for manifest necessity based on.
No, she abused her discretion the rest of the trial and pre-trial.
Well, but counsel, we also have, and not necessarily in this context, but we have in cases where there are evidentiary issues, where we have found that the trial judge abused their discretion when they didn't utilize something that they could have. And so in the record here, where there, again, it's not necessarily prescriptive, but there's 27B that says may, there's other things that could have been done short of declaring a mistrial. Is
That's not,
there
there
could
we
be
go.
an abuse of
wasn't
discretion
me.
because there's nothing to suggest that she went through the progression of what she could have done short of declaring a mistrial, which directly goes to not giving defense counsel an opportunity to say, hey, we've got all our heads in the courtroom. Let's all collectively think about this. And perhaps we can all come to some other vertical other than declaring mistrial.
Yeah, and I think it's clear from the judge's order that she was cognizant of at the time of these countervailing considerations, looking to the jury's notes, the lack of any indication of agreement on the charges, balanced against the risk of coercion, the defendant's trial strategy, and the fact that the defendant had not been advocating for the judge to do something more. I think it's clear that the judge was aware of these considerations and balanced them in a way that was not an abuse of discretion. Might a different judge have reached a different outcome here? Perhaps, but the judge's determination here, which is owed some deference, if not an abuse of discretion, was not outside the range of reasonable outcomes, given the jury's notes and these other considerations. Your Honor.
You don't think it would have been coercive to say, come on, jury, I know you say that you're exhausted, that any further deliberations would force us to compromise these deeply held beliefs, but did you reach a verdict on count one?
I do think that would be extremely coercive, Your Honor, yes.
How is that
I would point the
coercive?
court to footnote 5
What?
versus Commonwealth, where this court said or noted
You just
there may be a
told that
prevailing
fucking
practice
judge
among federal
bold-faced
courts
that
without
that would have been
inquiring into the
coercive
jurors'
for her to
strategies,
specify the
that long, or
charges,
perhaps further inquiry.
for her to ask the
That is
jury to
not
specify on the
prevailing practice
charges.
here in Massachusetts, and it's not an encouraged practice, particularly because of the risk of coercion.
I take it Rule 27 there's no discussion of Rule 27 at any point during the deliberations or sort of preparing for the deliberations, right? When we read through this whole record, we're not going to find any indication it was on anyone's mind, right?
Correct.
But so I see your point on the note is.
Did you see the look on her
so
face?
Compelling that they've worked this to the end. Then the problem comes when we get this new information that's somewhat inconsistent with that the key sentence, some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails. Then we get this motion for a new trial with 4 or 5 jurors saying that's not the case, right? That's the troubling part. What should happen at that point?
Yeah, and I do want to make sure I get to this, Your Honor. The alleged agreement reflected in those statements is not an acquittal. It lacks finality of a verdict, really for 2 reasons. One is the reason that's already.
I get that point. I'm just trying to figure out what should the judge do at that point? Because they're arguing, okay, you have some follow-up obligation here. Is there no obligation whatsoever, I guess, is what?
No, we argued below, actually, Your Honor, that it's
There's
not
no
reliable or
obligation?
competent evidence because it goes to the substance of the jury's deliberations and is being used to try and impeach the declaration of the mistrial based on the jury's notes.
The judge makes a finding that she finds them credible for the purposes of this motion, right? So she doesn't say they're unreliable, but rather accepts their reliability and then concludes that nonetheless that
Yeah, she was shocked.
can't inquire here without invading deliberations. It's different for reliability. She's given up the reliability point, right? She's made a finding that I accept for these purposes that those 4 jurors or 5 jurors
Correct.
are credible, right? So it's not a reliability issue that you can rely on, right?
Correct, but the judge also correctly or properly ruled that it would not be appropriate to conduct some sort of post-trial inquiry at this point.
Bro, this guy's melon is totally in the way.
A mistrial was declared, this jury was discharged, they've now been discharged for 4 months. They have no power or authority at this point to come back and render a de facto verdict.
Well, the request is to inquire of them, which we said you can do in Fiddler and McGowan et al., right?
but not to get into their
Well,
deliberations.
that's a separate matter. You said that,
Correct.
you can't bring this jury back. You can bring them back for post-verdict inquiry.
Well, it's one,
Under the guidance of FIDLAR, et cetera, right?
it's one thing, Your Honor, to bring a jury back and inquire as to extraneous influences to determine whether a verdict that was returned and affirmed may have been the product of other than a fair and impartial jury. It's quite another to bring a jury
Yeah.
back to essentially construct.
AJ's
a
got
verdict
a,
that was
he's
never-
growing a
Weinberg
beard.
argues
He's at that
it's
awkward phase where he looks
protected
like
on
he's
the
been on a
Second
coke binge for
Amendment
fucking 4
for
days.
your trial, but he says we should expand our law.
It's gonna look
I
good, though.
Understand him to include the Fifth Amendment right and double jeopardy protections as well. What's your response to that? Why not?
I agree with the reasoning of the appeals court in Di Benedetto that it can't simply be the fact that it implicates a core constitutional right to allow for this sort of inquiry. And here, unlike.
Why not? Why is the Fifth Amendment any lesser of a right than the Sixth?
It's not that it's any lesser of a right, Your Honor, but although it is different than the Sixth in that here there's, a balance of two competing public policy considerations. It's not simply the defendant's right, there's the public's interest and right as well. So it is different than, for example, the Sixth Amendment right.
Well, doesn't the public have an interest in finding out the truth of what the jury decided?
They have an interest in a just judgment that is in fact a final outcome or final verdict here. But setting aside whether expanding it might be appropriate, it cannot be done in this case without getting into the substance of the deliberations. And I think my brother revealed that under questioning. There are several issues with it. One is, again, this jury has been discharged now for more than 4 months and has been subject to extraneous influences, potentially including harassment.
We've
Or
sent
threats.
back.
Yeah,
juries
from
in
Plevin.
case- I can't remember how many years. It was like a decade later or something. Timing is not going to be a winner for you, is it? It has to be.
No, that by itself, Your Honor, is not a reason not to do it. I'm raising it as an additional consideration or concern here. But there are others as well, which is it's not simply a matter of bringing a jury back and trying to ask them a yes or no question. That's not how juries reach verdicts. We ask them to engage in group decision-making, collective discussion, review of the evidence. So it's
Our post-verdict inquiry is guided.
I hate
we
this
always
smug little
say
shit.
To the jurors and we tell the trial judges. You have to instruct the jurors, do not tell me about the contents of your deliberations, answer this specific limited question. And the limited question posed by the defense, and I think in the ACLU brief, is did you reach a verdict essentially on counts 1 and 3, or was it an acquittal? Right?
I don't know that was the specific question they proposed, but I understand. I take Your Honor's point.
However
Yeah.
they phrase it, it's a limited yes/no question.
Yes, and my point is that's an artificial inquiry. Or take, for example,
We asked,
Did you-
have you reached a verdict? That in and of itself is a standard question, right? That can't be crossing the line, right? Or is it?
no, but again, I want to reemphasize the point that was raised earlier, which is imagine a juror had tentatively agreed to find not guilty on a particular charge. But that was subject to further deliberation or consideration. Maybe the juror wanted to see what happened with the other charges. You now bring the jurors back and you simply ask them, I don't want to hear anything else. I just want a yes or no. It doesn't give that juror any opportunity to explain that their agreement was tentative at that point. And so it's an artificial
Thank you,
exercise
corruption.
Is
to say,
that what Bloford, is that Justice George asked your brother counsel about Bloford? Is Bloford the answer for you that that's what Chief Justice Roberts was saying in Bloford, that it's always tentative? Or is it's only in lesser included that works? Because I asked Mr. Weinberg, is there a federal case right on point that we can look to? You at least have Bloford. Is Bloford controlling? And it's the Supreme Court.
would argue that it is, and I actually take it one step farther, which is not only is there the concern that was raised in Bloford that the perceived agreement or unanimity here may have been the product of a very early discussion subject to further deliberation, but jurors are free to change their mind and change their vote right up until the verdict is affirmed and recorded. They could vote guilty, walk into the courtroom, and at that point change their mind and say,
My banner CC.
not guilty. So even if.
Like David
counsel
Banner,
wants to
like the
argue
like
this
Bruce
was
Banner,
a
like the Hulk.
final vote, this was a final decision.
I don't know what you're.
You still can't rule out the possibility that any juror was free to change their mind had they been required to go through the full exercise of rendering and affirming a verdict.
Can I ask, is their argument what Justice Sotomayor wrote in dissent in Bloford, or is the different?
To characterize
Mhm.
counsel's argument, I think that they are relying on that for the notion.
I don't
that
have
giving an acquittal in
Mark
substance is
Ruffalo
not formal.
or
Those are
Edward
cases
Norton
Justice
or
Sotomayor
Bru-
cited for that
or
proposition. They're all cases
Bill
involving
Bixby up
judicial
here.
rulings. They're not
I don't know what
cases
you guys are
of
talking
determination.
about.
I'm not aware of any federal authority that supports the proposition that there can be an acquittal in substance but not form, or I guess more to the point, says that a state cannot impose the requirement that a verdict be affirmed and reported. I think if anything, Bloford acknowledges that that could be a perfectly legitimate requirement where it said, take the defendant's argument here on its own terms. It wasn't a final result, quite apart from the requirement to render a verdict or a judgment. So I think Bloford does support our case, Your Honor. I just do want to emphasize that it's not only just the possibility that there could be a change of mind during the deliberations itself, but even after that.
Bloford limited to lesser included.
The ticker. You mean like somebody's heart? Got a bum ticker.
Opinion.
Like a clock?
I don't read it that way, Your Honor. No,
I don't know what you guys
read
are
it
talking
just
about.
The general proposition that there are multiple charges, whether they're lesser included or not, jurors remain free to go back and revisit a prior vote. In fact, I think the court said that although Arkansas was an acquittal first jurisdiction, nonetheless, the jury
Move the
remained free to go
closed.
back and revisit a prior
Captions
vote because
up.
that's what jurors
What's
do,
captions up?
and it wasn't inconsistent with the instructions.
I don't understand. Move the closed. Moved what
I
closed?
want to emphasize one other point, which is
I need
at
you guys
most,
to
what we're talking
enunciate
about
your
here
words,
with
please.
these juror
Your
statements is a
sentences.
snapshot of the jurors' deliberations, but you cannot short circuit the verdict requirement and rely merely on such a snapshot. And it's important because it protects defendants too. You could imagine a different scenario where juror comes forward and says, notwithstanding the declaration of a mistrial, we all took a vote and we found the defendant guilty of murder. If the Commonwealth were to come forward and say, effect should be given to that vote, there can't be any serious doubt that the defendant, whether in this case or in a future case, would argue that is not a valid verdict and shouldn't be given any consideration. Unless your honors have any other questions, Commonwealth would ask that the defendant's petition be denied.
Okay, thank you very much.
Thank you.
He's a fucking arrogant little shit, isn't he? Kind of reminds me of Edward Norton. Supposedly Edward Norton's like really difficult to work with because he's an arrogant little shit too. All right, so what happens now? Yeah, I know. That was frustrating. I could barely read the closed captionings the whole time. I couldn't understand. It was really weird. I don't know why they had them so low. I wish that they had the closed captions higher so that I could read them better. Is that it for the... It looks like that's it. It looks like that's it. Strange. I don't know why they did that. I mean, I wish that they... I could only read half of them the whole time. It's a good thing I was wearing headphones. I could hear, you know? That was good. That was good. You hear Clubber snoring? We won't know anything for a bit. Okay. Thank you, Liz Reed. Good to see you. You keep... Why the Hulk references? I don't understand the Hulk references. You guys keep talking about David or Bruce Banner, and it's really weird. I don't understand. Let's see what's going on with Tom and Mike. Hold on. What's up, JFK? It's good to see you, buddy.
Yeah, we got you.
So there's going to be a press conference outside. I'll see if I can find like an actual press feed of it. Because NBC 10 Boston is still live, so. So there's Alan Jackson.
Yeah. Can you say one more time your questions that you heard
Tom's
I'm doing?
StreamYard sound is really
Very good,
bad.
thank you.
And Boston 10 is still live, but they're not showing this, which is really weird that they don't have a feed for it. So we couldn't hear what Alan Jackson was saying.
Liability, Karen? Are you and your family afraid of
Oh my God.
I just
Fucking Grant. I wish I could hear what Turtle Boy's asking. It's too windy. Can't hear.
ask some questions, huh? Like Casey with APS, my card. It's
Closed captions would be good, but I wish that they'd have them higher so you could read them, you know? Weird place to put them. So low on the screen.
good to see you. How are you today? Good to see you. All right, guys.
Fucking
There
Grant.
you are. I was looking for you. How's everything? Good to see you. Yeah, thank you. Good to see you, Nathan. Good to see you. Don't worry about Grant.
What was Grant asking? Did he say something about a baby?
All right. A text message from John McDonough to Karen Reed, indicating that Karen and her family are afraid of you.
This is an excellent, this is an interesting outfit you chose for today.
Where's the road? Did you run out of now tell me, is Karen said that you're a liability. Is that because you conspired with her family and Karen to intimidate witnesses in the race case?
Donut? What is that? How'd you clean yourself up?
That's a real text message, isn't it? I'm still taller than you.
So, anyway, Grant, what's it like to be perpetually in the friend zone? How does it feel to be perpetually in the friend zone?
If Karen Reed is afraid of you, it's going to seriously trouble you out.
You still live with your mother? Do you live with your mother?
Don't stand by him. You saw that
Do you
text
live with your mother?
message. Karen said she's afraid of him. Karen said
I stand by.
Don't touch me. Tom, go back. Tom, come on, dude. Go back.
It's clearly.
All right. No, yeah. Good job, Tom. Good job. Way to go, Tom.
I wouldn't normally ask about money, but your daughter did this vanity fair interview. Said she's millions in debt from this trial. What kind of financial goals is taking on your family, especially?
Well, I think what you said, you can see from these expenses.
I wish it wasn't so windy.
Not necessarily funny.
But good on Tom for going over there.
The need for justice to prevail. I think that would be Davey and Eddie, Ellen Jackson,
lies a little on Weinberg, whoever it may be, in our corner, civil lawyers. It's there because it's more than just compensation based. It's justice based. My daughter is factually innocent. Is not a person who has witnessed what we saw in Norfolk County, inverted videos,
Get him, Bill.
testimony from Massachusetts state troopers that is disturbing. So my family's waiting. Thank you so much.
Poor Bill,
Have a
man.
good day, Mr. Mason. Thank you.
Bill looks so exhausted. I feel so bad for
Not
him.
bad, huh?
He's so strong, but he's
What,
so
he's just, I mean, can you imagine bringing him to a
rightfully
party?
exhausted.
Grant, that ain't happening, right?
I was kind of mad at
Not only
Tom.
would he get kicked out, you'd get kicked out for bringing him.
I was kind of mad at Tom for running away from Grant and Turtle Boy, but I'm glad that he went and caught Bill, man, because that was a smart move. That was a good move on Tom's part there. Because you know the news is going to edit the fuck out of that. You know what I mean? Like what Tom's doing out there is so important. It is so important. Because he's showing you what the news won't. Yeah, there's more tomorrow, I know. We'll be streaming that tomorrow as well. Thank you, Cherry.
Isn't that the truth, guys? Really?
Yeah, that's facts, man. That's facts.
Hey, Shelby, can you put me back on? I'm gonna log off.
Hey, yo.
You there?
Yeah, we're here, bud. Can you hear me?
Yeah, I hear you. That was a good job. That was a good job.
That was something, huh?
Yeah, man. That was
Got
good.
the got our parents out there,
Yeah.
which is
Way to
good.
go.
Hey, make
Nathan was
sure,
there, her brother.
Yep.
make sure
So,
to give
yeah.
Tom and Mike a like.
I think it went well, in my opinion.
Click on the link
I
just
didn't
dropped.
get a chance to hear much of the inside.
Yeah.
What-
when you get a,
What
yeah,
happened on the inside?
Well, Marty Weinberg.
Give Tom and Mike a like for me. I just dropped the link. Subscribe to Seeking Justice with Tommy and Mike. What Tom's doing out there is really important.
Prosecution stood up for maybe 15 minutes. I think I don't know. It didn't go for the prosecution. It didn't go well, in my opinion.
All right.
So
Well, that's
I
a good
think-
thing.
Yeah, go back and watch the tape if you can today on your way out.
Trying to figure out.
Yeah, right
All right.
home. I think I'll listen to it.
All right, I'm gonna check out. All right,
Yes, sir.
I'll talk to you later.
Catch you soon, my friend.
All right, guys.
Hey, send my love.
Boston Mike, y'all. We love Boston Mike.
All right, guys.
We absolutely.
Imagine that. Hey, see a new member here. We got members. We got members. Woohoo. Thank you, everybody. Everybody today. No, my pleasure, guys. I'm here for you guys, right? That's why.
Yeah, like so the whole Weinberg thing, man, like I mean, it was frustrating because it seemed I've never seen a hearing like that, so I'm not really familiar with it, but I was frustrated because it seemed as though, you know, the judges were being just hard-headed. That these justices were just being hard-headed is what it felt like. But they were basically playing devil's advocate. They were trying to eliminate the fat and get to the meat and potatoes here by asking hard questions, and giving the attorneys a chance to argue. But it was funny because once they got around to Pee Wee Herman and his question and his case, they were basically just keeping it real simple. Like, why wouldn't the judge just specify on those 3 charges? I mean, come on.
Massachusetts. That's kind of the issue, so. All right, Scott. Talk to you, my friend.
Yeah.
Be good. Have a nice ride home.
Hey, John.
Good, you?
Good, thank you.
Enjoy the day. Yeah, look at all this barricades they put up and everything for us, right? We don't need it. We don't need any of it. All these, this is all, yeah.
Hey, correct.
No need for
Welcome
that.
to Logic.
Jojo, my pleasure, really. Yeah. Really, you guys are great. I love all you guys. So, I hate being a friggin' stickler here, but we're having a little shindig type of a thing December 8th at the Star Drive-In. It's a family-orientated thing. There's gonna be a lot of good vendors there. I know there's gonna be some great food. There's always great food there. And yeah, looking for donations. Looking for the blow-ups, the yard blow-ups. So if you have any yard blow-ups, we need to borrow them for a day or a weekend, December 6th and 7th. We're gonna set up the like a path with the lights and everything so you guys can walk. And yeah, do something family orientated for a change. You know, I think Santa's gonna come.
All right. Dude, like, yeah, so I mean, we're not going to know anything just yet. So and tomorrow there'll be another hearing, and I think Jackson and Eddie are going to have a chance to make their argument at 10 a.m. tomorrow. So we'll be here for that. But it's still early, guys. So let me do this real quick. I'm beat, man, but we'll hang out for just a little bit longer. Okay. Just a little bit longer. So if anybody wants to call in, they can call in. Phone lines are now open. Yeah, court is over for today. That was it. I may go live a little later tonight. Pretty wild, man. I was live for 9 hours last night. We just ended up covering the election. And listen, liberals, don't get mad at me. Although I'm glad that Trump won, don't get mad at me. I voted for Joe Flipperhead. Okay, so that's just not my fault. Don't get mad at me. But yeah, I'm glad Trump won. I'm excited to see what the next 4 years are going to be like. I'm really interested in seeing what that's going to be like. So I say a lot. I am a douche. And I'm going to keep saying because it's just something that I do. It's not exhausting, actually. I quite enjoy it. Saying is one of my favorite pastimes. How's being a douche? How's that working out for you? Yeah, Rob, I agree with you. And people are like, "Oh my God, I can't find it." I took it down, man. I made it private. I took down the live stream. There was no reason to keep it up. And plus there was all kinds of copyright dings on it and shit. There was, that was just for the experience and just hanging out. I had a very, very small little intimate thing going on. There was only about 200 of us. It was nice. It was pleasant.
Call from
You're on. Who am I speaking with?
Bill and Janet's daughter, Liz.
I can't hear anything you're saying.
Hold on.
Okay. What? Yeah, last night's stream was fun, man. It was fun. We had the best stream. It was tremendous. It was a tremendous stream, the very best. There's never been any stream like it. It was the most presidential stream of all presidential streams. There's never been any stream that has ever matched it. It's the best best stream in history, really. It was a tremendous stream, the very best of all streams.
Call from
Hello.
Hello.
Yes.
This is Bill and Janet Reed's daughter, Liz.
Oh, what's up, Bill and Janet Reed's daughter, Liz? I'm guessing that wasn't Bill and Janet Reed's daughter, Liz. Just gonna take a little stab in the dark and assume it's not who that was. Well, thank you for watching, Sharon. I appreciate it. Yeah, nobody feels like calling. So, I don't know. I mean, it's a small crowd today too. So, look, it's the same person.
Call from Liz.
Hello. And then they keep calling and hanging up. Hello.
Call from Jay's Handy.
You're on. Who am I speaking with?
Hi, Will. It's Hate Corruption. How are you?
What's up, Hate Corruption?
I just wanted to call and say hello because the phones weren't ringing. So
Okay. Well, thank you for calling. How are you?
I'm doing okay. I'm in the hospital. I had to have a hip replacement yesterday.
Oh
so.
my goodness.
Yeah, I'm okay though.
Yeah. That's usually a pretty basic procedure.
Yeah, they're
common.
probably gonna keep me here today, and then I'll go home tomorrow. I had my knee replacement done here about 8 years ago, but the pain is already gone from prior. So that's great.
Well, that's good. Right
But
on.
okay.
All right. Well, I'm
Yeah,
glad.
I just wanted to say hello to everybody.
I hope you're feeling better soon. Get better.
I'm feeling better already.
Good.
I mean, like I said, nothing's like the bone-on-bone pain.
Right.
But I'm gonna be okay.
Right on, Hate Corruption. I'm glad you're on the road to recovery. Thanks for calling.
All right, man. Bye-bye.
All right. Bye-bye. She hates corruption. Of course. Yeah. She hates corruption. We all hate corruption, don't we? I didn't want to get into that. I didn't want to get into that. I I feel bad that she's in the hospital, and you know, but she seems to be in good spirits, so that's good.
Call from.
You're on. Who am I speaking with?
Hey, it's Elise from Las Vegas. How are you?
Hey, Elise from Las Vegas. I'm doing great. How are you?
I'm great. I want to give a shout out to my sister. She was there today in court.
Okay.
Yeah, Nicole. She's a mom of two, very busy lady, and like she just made it a priority to get out there and support Karen.
Hell yeah.
I think she said she got to sit next to Kelly Reed and right near Karen's family.
Okay.
And I just want everyone out there, especially that's local, to like get out there and support her. It's just incredible what's happening. And I don't know, how did you think the hearing went?
At first I was a little frustrated because it felt like the justices were just dense, you know, and
Yeah.
it felt like Marty Weinberg, at some points I was like, oh man, he's dropping the ball, you know. Like I feel like it's a real simple thing, and you just focus on the simple aspect of the fact that it's on the judge to instruct the jury to specify each charge. And I felt like that was the main focus point. So when he seemed to deviate from that, I would get frustrated. But as it progressed, and he closed strong, and it made sense as to the argument that he made once he closed, and then I was like, okay. And then I saw a little bit more of what the justices were doing and how they were going about this when they were asking the representative of the Commonwealth, asking him questions.
Right. It was good to see them. I thought they were equally as hard on the Commonwealth, because at first I
Right.
was a little bit nervous, like, oh shit. Yeah. I wonder why it didn't really come up that the jury instructions said repeatedly, until you've had a decision on all three counts, don't tell us what your decision is. So I'm wondering why that wasn't part of his argument, unless I missed that. But
Right. And it was weird to me because he wasn't correcting every time the justice says, you know, the charges, you know, that was never specified, you know.
Right.
Like when she says that that's what the jury note said and quotes that, I'm like, wait a minute, that's not what the jury note says. The jury note never specifies charges, never says the word each charge or charges, you know.
Exactly.
So that's the problem here. It was just a very vague, you know, they were at an impasse, but it was never specified on what. That's the issue here. And so he simply wants to have the judge conduct a voir dire with the jurors individually and simply ask them, did you come to a unanimous decision, and what was your decision? Very simple, not inquiring into how did they come to that decision.
Right.
So to me, it's really simple. You know what I mean? So when I'm hearing all of this discussion about it, I'm like, that's we're getting off base here. Like, this is really simple. Like, let's just stay focused on what matters here. That was my take on it.
Right. Yeah, very interesting to watch. We'll see what happens. And then shout out to Jackson Scruff. I'm hearing reports from my sis that, you know, it's looking pretty good in person. So
is it? Okay.
As long as everybody out there gets the real scoop, we just have to also report on
because
that. You know?
Yeah, he's getting some criticism in the chat here.
Really?
Yeah. People are thinking that he's going for a Serpico vibe, and it's not working.
Oh man.
But
gosh.
But you're saying that in person it plays. I believe that.
Yeah, that's what my sister reports, you know, so I'm going to go with her. I think you met her in Boston last time you were out there. So
maybe, I don't know.
Yeah, she was in your picture that you guys did, but yeah. Yep. All right. Well, thank you so much for all your reporting. It's been a pleasure watching and following, and free Karen Reed, everybody.
Free Karen Reed. Thank you so much. Appreciate you calling.
That's right. All right. Have a great day. See ya.
You too. Bye-bye.
All right. Bye.
She was awesome. It looks like he's falling off the wagon. It's funny.
Call from.
You're on. Who am I speaking with?
This is Adam from Wisconsin.
Adam from Wisconsin. What's up, Adam from Wisconsin?
Also known as Donkey's Noggin in your chat.
Donkey's Noggin. I love it.
Yeah.
Jackass's melon.
Was the gym open today?
I haven't gone yet, but yeah, they're open. But yeah, I'm going after a well-deserved nap. I mean, I was only live until like 3 a.m. last night for 9 hours, and then I woke up to do this shit.
Yeah, I missed a lot of that. The old lady had surgery from a hysterectomy for cancer, so I gotta take care of her like a little baby.
Oh, sorry to hear that. I hope she gets better soon.
Oh yeah, she'll get there soon. She'll get there. She's a tough little Irish lady, so it drives me nuts. But
yeah,
I guess it is what it is.
Yeah.
No, I mean this whole I'm ex-military, retired, and this whole BS.
Well, thank you for your service.
Thank you very much for your support. This whole thing is just a straight up bully. You know,
Right.
like all these people being a bully and everything. And I can't stand bullies. I can't.
Yeah.
You know, I know people got their own opinion. I got that. Don't listen to it, whatever. But they're going after a lady that is literally draining everything out of her. And for some ungodly reason, she is just standing strong against the waves. You know, and what makes me even more mad too, that not mad, I'm gonna say just disgruntled, I guess you could say, that the FBI or whatever, you know, might have a part in this whole situation. And it's like, you know, somebody should step in. I know they can't, but somebody should step in and just stop this draining, like especially, you know, funds.
Yeah.
You know, eventually she's going to run out of money. Then who the hell is going to defend her?
Well, that's why she.
You know?
That's why we need to continue supporting her. You know.
Oh yeah, I definitely agree with that too, and I also believe that, you know, everything happens for a reason. I believe that these people that have, you know, tragically passed away, you know, put the wheels in motion to stop all this. Because if it wasn't for the resources that she's had and the support she's had, let's say it was you or me that barely has any money, like, what do we do?
Yeah.
You know,
I
because you don't even know where to.
Yeah, and I think that she's doing everything that she can, you know, and I'm not in this for anything other than just her to continue fighting as hard as she can.
Oh yeah,
you know?
I see your passion, and
that's all I want from Karen Reed is for her to continue fighting, and that's it. I don't want anything else from her for this.
Oh, I believe I see the passion that you have, and I understand who you are. I understand who you are. But enough said already. I want to get other people on here so they can chit chat. It was an honor meeting you.
Oh,
And
right
thank
on.
you for what you do and everything, brother.
You too. Thank you for calling, and thank you again for your service. I appreciate you.
Oh, thank you for your support, sir. Have a good night, or
You too.
have a good day, actually.
Yeah,
All
right
right,
on. Have a good one. Some good callers today, man. I love that. I love that. Nice, chill vibe. Take a couple more. What's up, Bestie? I see that you were inside the courthouse, you said? Cool, cool, cool. I love it. That's awesome.
Call from.
You're on. Who am I speaking with?
Hey, Wilt, Pennsylvania Dave.
Pennsylvania Dave. What's up, my man?
You got it, my brother. Listen, what you're doing here is awesome. You are. You are awesome. We watch your show all the
as
time.
awesome as you, Pennsylvania Dave. And,
Well,
and by the
we have
way,
our
guys,
share of
don't
sta-
ever play cards with Pennsylvania Dave, okay?
Why not?
Because
Why not?
listen, 3 rules to live by. Never get less than
Go ahead.
never get less than 12 hours sleep. Never sleep with a woman with a tattoo of a dagger on her body, and never play cards with a man with this got the same first name as either a city or a state. Okay? Stick with
Yeah,
that.
well, that's not my
Everything
first
else
name.
is cream
Pennsylvania
cheese.
is not my first name. Pennsylvania is not my first
No,
name.
I'm
It's
kidding.
Dave,
I'm quoting a movie. It's joking.
that's
around.
cool. That's cool. I know what movie you're talking about.
Oh yeah,
Yeah,
which
me
one
and
is
my
it?
wife. I can't remember, but I heard the rules. I know the rules.
Yeah. Teen Wolf, 1985. Michael J. Fox.
What'd you think of that hearing this morning?
I mean, I feel like Marty Weinberg presented a good case. And I think that dude was trying to like Pee Wee Herman, representative for the Commonwealth. I felt like he was trying.
Yeah, Schilling.
I think he was trying. I think he was trying to cause a little misdirection. I think he was trying to be slick, and I think that at least one of the justices were onto it.
They were, no doubt.
So yeah, I'm still optimistic.
The only thing that bothers me is I don't know Weinberg didn't give him the jury instructions that she gave them. Unless you're unanimous on all 3 counts, do not come back to me.
Right.
That was a ploy from the beginning, because personally, I think Cannoni's corrupt. That is the bottom line.
Me too.
Everybody does.
Yeah.
You said it a million times. She is just plain out corrupt, and she is.
I agree. Yeah.
And I don't know why he didn't say, if you look at the jury instructions, do not come back to me with a verdict unless you're unanimous on all 3 counts. That gives them a reason not to fill those papers out.
Right.
And those are piss poor instructions, Will.
They are. Yeah, the whole
They're
thing was
piss poor
shady.
instructions.
The whole thing was shady, and the defense called her out on it. Yeah, the defense called her out on it, and then when the defense called her out on it, then she took it out on Karen. Something funny.
Yeah, when they came...
Something funny, Miss Reed.
Yeah, I know. That was a freaking joke. When she had the opportunity, she sat down. I'm not going to put you through this. I'm going to declare a mistrial. Get the hell out of here. She had every opportunity to say, are you guys unanimous? Are you guys hung on all 3 counts?
Right.
No, Your Honor, we're not. Well, which ones aren't you hung on? 1 and 3.
Right.
Well, let's pull the jury.
It's smoke and mirrors to try to put this on anyone but Judge Cannoni. And I've been saying this from the beginning. Ever since this happened, I was like, this is on Judge Cannoni. Like, and,
it is, well.
And for her to have to, to dismiss the charges, or to even, allow this voir dire of the jurors, that would require her to admit wrongdoing. Even through her actions, even if she doesn't verbally admit it, through her actions would be an admission to wrongdoing. So she's too proud to do that, and now here we are. Now here we are in front of the Supreme Justice Court. I mean,
I have been around courts my whole life. I have never seen a judge kick a jury out of a courtroom as fast as she did.
Yeah.
Your service is concluded. Get the hell out of here. I'll be back to talk to you in a couple minutes. And they were on that bus immediately.
Yeah, and they've even said, they even reported like that they were like, dude, on the bus, they were like, does anybody feel fucking weird about what just happened here? Like,
they all said that, but what are they going to do? And I think that
they did what they did. They went above and beyond their call of duty. Because if they were acting and they're sworn to act in the interest of justice, that includes being on that bus, feeling something wrong about what just took place, and then coming forward and reaching out to both the Commonwealth and the defense on this issue. And that's exactly what they did.
Well, I don't understand when those couple jurors in there said, why don't we just send her a note that we're unanimous on 2 charges? And the jury foreman said, oh, no, we can't do that.
Right.
That is the crowd. If I was on that jury, I would have stood right up and I would say, Judge Cannoni, we were unanimous on 2 counts. If somebody wanted to say that we weren't after we went out there, that's a different story. That's on you. But no one was allowed to say nothing. He did all the notes. He did everything. And maybe he should, but somebody should have stood up and said, this verdict is not accurate. And I don't know why they didn't. Maybe no balls. I don't know. Maybe they were intimidated in there. I think they were. But that is just my opinion.
Yeah. I mean,
she knew exactly who she was throwing off that jury, never showed the defense any of those balls, never, and knew exactly who she was appointing for the foreman. It has corruption written all over it.
Yeah. Yeah. I mean, this whole thing has stunk to high heaven since pretrial. So,
I mean, you got to stand up and be a man and say, this is freaking wrong. I can't wait till Josh Levy swoops in there
yeah,
and puts them all in jail, because they are going to jail. Don't think he doesn't know exactly what happened through this whole thing.
Right.
He already knows.
This is
he's
all,
just,
yeah,
he's just
all
giving
the
them enough
corruption,
rope.
Right. All the corruption we're witnessing is all indictable. I feel like
they already know about it.
Right.
They're just giving them all enough rope to hang themselves.
That's what I believe. That's absolutely.
And you got to figure who the weak links are. I'm telling you right now, Tully is a weak link.
Sure.
When they put him in a room and threaten him with 20 years in jail, he's going to sing like a freaking canary.
Right. Proctor as well.
There is no doubt. You bring every person that was in that house that night into a room, and you put Sarah Levinson in there, who's taken all this traumatic therapy, and threaten her with your life in prison, she will sing like a canary.
Yeah, Guadino too.
That's the one thing they haven't done yet, is put those people in separate rooms.
Guadino's got shit on not just people involved in the Karen Reed case, but also Sandra Birchmore.
Mr. I can't find 32,000 text messages. Are you freaking kidding me?
Right. Yeah. So if
look the other way, Will.
If they could flip that guy, which it should be easy to flip that guy, because that guy did some dirty shit, you know?
Didn't he just get all banged up? Didn't the drunk driver just drive into him?
I don't know.
Wasn't he the Massachusetts state trooper who got hit? I'm pretty sure that Aiden said that he was the guy who got hit by the drunk driver.
I don't think so. I don't.
If it's accurate, I know there was an MSP state trooper who got hit by a drunk driver.
I know there was an MSP state trooper who just graduated from the academy who hit somebody because he was drunk, but I don't know what you're talking about.
Congratulations, Anna.
Yeah,
I don't know, but it was on the news that he was on the highway. And a drunk
people in the
driver
people in the chat are agreeing with you. I just didn't know about it.
Yeah, and Turtle Boy said it was Garino who actually got hit.
Wow.
You talk about karma?
Jesus Christ.
Talk about karma, Will?
Right. Yeah, and there's so many.
How do you like this, Mister? I can't find these deleted text messages, and that search never occurred. It occurred.
You've got Chris Albert, who killed somebody with his car, drunk driving.
Yep.
You've got the other guy who smashed into somebody, the chief clerk of the courts. He smashed into somebody drunk. I mean, and then there was somebody else who smashed into somebody drunk, and I can't remember who it was. I mean, it's so crazy. Like, it's so crazy. And
Will,
and
what about
and the one person who's being actually accused and her life is on the line for it is the one person who the evidence dictates did not hit anybody with her car. So, and she's on trial for it. It's insane.
Let me tell you
Paul
something
O'Keefe.
right now.
It was Paul O'Keefe. Excuse me. Paul O'Keefe hit
If
somebody.
she
with his
would have
car.
hit him at 25 miles an hour, half his body would have been broken. But according to Trooper Paul, his arm was more like this. Who stands outside with their arm in the air like that with a cocktail glass in their hand? Most ridiculous thing I've ever seen in my life. Are you kidding me?
It really is.
And Canoni did not want those crash daddies on that stand because the FBI sent them a letter saying, "This is in your best interest not to prosecute this case," and they didn't listen to them.
And then Rafferty,
they already know what's going on.
And
they know what's going on.
And Rafferty hit a pedestrian.
Yeah,
like
he did.
Like
How
an
could you
old
get
guy.
any crazier?
Like, right?
How could this get any crazier?
That's
The
insane.
whole world knows. The whole world knows that this chick is getting framed. They know it. And they just don't want to hear it. We don't care. We're prosecuting her. We need somebody to take the blame for this, and it ain't going to be the McAlberts.
Right.
And don't think Paul O'Keefe doesn't know what happened.
Paul O'Keefe knows.
Don't think he doesn't know. He knows.
Yeah, I'm done feeling sorry for that guy.
Yeah, you know
Yeah,
what?
I'm done
He is. Did you hear he took that GoFundMe money for those kids and went and redeveloped his house?
No.
How sick is that?
I didn't know that. I mean,
yeah, he put an addition onto his house. We have documentation.
Wow.
He paid off a $230,000 line of credit mortgage right after that money hit his bank account because he was the beneficiary.
Wow.
Yeah.
What a
You
douche.
look into it. It is there. Took it right out of the bank, paid off his home equity line of credit in less than a month.
Wow.
All the paperwork doesn't lie. Cell phone messages don't lie.
Wow.
They don't lie. That extraction that they took off of what's her name? Horseface's phone.
Crazy.
227 search.
Yeah,
It was
Jen
there.
McCain.
There's no doubt about it. There are experts all over the country who said that search occurred. But you
Yeah.
know what? Carino said, nope, that didn't happen. And who's that other guy? Gliffin or whatever his name is up in Canada? First of all, he's in the wrong part of the country to even be saying this with his self-found app that he's trying to sell. Well, the search didn't occur then. Yes, it did. They search my phone and I have something like that on my phone. You know where I'm going for the rest of my life? Right to jail.
Right. Yeah.
Not Jennifer McCabe, though.
This is crazy. Yeah, it's crazy shit. All right, man. I'm gonna let you go. Thanks for
Thank you.
calling. I appreciate you, man.
I will. Hey, look, I know you jam. You ever want to start a band? Let me know.
Maybe one day. We'll see.
I love you, brother. I'll
All
see
right,
you
man.
later.
Have a good one.
Have
Bye-bye.
a good day.
All right, folks. I'm gonna wrap this up. I'm beat. I'm done. Stick a fork in me. It's over. I appreciate all you guys hanging out with me, man. I had a great time. But yeah, you guys are amazing. Thanks for if you guys are new subscribers, thanks for subscribing. I hope you continue to enjoy the channel. And please make sure to hit the like if you have not already. It really helps me out. And for all of the support, thank you guys so much. I appreciate all you guys. You guys are absolutely amazing. Who says that? Mazza Media is going live at 11:30, so make sure to tune into that. Go check out Mazza Media at 11:30. Guys, I love you very much, and we will do this again very soon, my friends.